Well, now there's a huge backlog of cases in the criminal courts caused by a combination of underfunding for years and exacerbated by court closures during the last 15 months. Some defendants are waiting 2 or more years for a trial, meaning that the recollection of witnesses becomes unreliable as more and more time passes, and victims feel they're not getting justice as months and months elapse and no one's taken to trial. The normal court sitting day is 4.5 hours. It's 10:30 in the morning to 4 o'clock with an hour for lunch. Now, the Lord Chancellor, Robert Buckland, has proposed that courts should sit for longer days. He's proposing that some courts run not 1, but 2 trials a day, one starting at 9 a.m. and running for 4 hours till 1 p.m. Sorry to throw all these figures at you. And the next starting at 2 o'clock in the afternoon and running till 6 in the evening. He's also suggesting that court hearings which don't require a jury, such as sentencing and preparation hearings, should take place also outside normal working hours. Now, are these proposals a good idea? Well, I'm not a criminal barrister. I've never defended or prosecuted anyone. I specialise in a different area of law, and I'm not qualified to comment on this. But I know someone who is. Max Hardy is a criminal barrister at 9 Bedford Row, and he joins me to discuss the proposals. Max, is there a general consensus at the criminal bar about these proposals? Good evening.
Good evening, Daniel. Well, yes, there is. This is something that has been met with a great deal of dismay by criminal barristers. And the reason is that this is a proposal that keeps floating up. And just when you think it's gone away, it comes back again. And it's, on the face of it, potentially a very sensible proposal, because it looks as though you're getting 2 trials done in one day, where at the moment you're only getting 1 done in one day. But the reality is that for the people that actually administer the criminal justice system, this is going to impose an almost impossible burden, because although, as you described, a court day, in fact, most courts now sit 10 until 1 and then 2 until 4:30. So they've managed to eke out an extra hour from the figures you've quoted, which really applied when I started. But judges will often say to juries, you might be quite shocked that you're only at court for a comparatively short period of time. But the reason for that is because of the amount of preparation that goes into putting on a criminal trial. And that's really the main issue with these proposals to fit 2 trials in one court in one day, because it's going to hit the ability of barristers to prepare for trials, but in particular, it's going to hit barristers with caring responsibilities, because if you've got to be in a courtroom ready to start at 9 o'clock, you of course need to be at the court building a good deal before 9 o'clock, which means things like school drop-offs become an impossibility. And likewise, if you're in the courtroom until 6 p.m, there's no way you're picking up children from school or childcare. And this in particular hits caregivers. And unfortunately, it remains the case that in many cases, that is women barristers.
How is this different, Max, to any job where the people who do the job have to work on social hours?
Well, that's a very good question, because I can see why this might seem a rather bizarre complaint. And it's because most jobs, you start the job when you start the job, and you finish the job when you finish the job. And as you will know from your area of practice, and in this sense, your area of practice is just like mine, the barrister's working day is not just when they're in court. We don't just turn up at court, open a file, and start reading from the file. Many, many hours of preparation have to go into what happens in the courtroom. And for criminal barristers on legal aid, that's not paid on an hourly rate. All of that comes out of a flat fee that's paid for the case. And you simply need to have time in your day to do that preparation, because otherwise, as I say, anyone with caring responsibilities or any kind of hope of a family life just cannot be a member of the criminal bar.
Well, if you're prosecuting or defending a 4-hour case or 5-hour case during the day, how many hours would you have to put into the preparation beyond the 5 hours in court?
I mean, it does, of course, very much depend on what sort of case it is. So a shoplifting case, and you still get shoplifting cases going to the Crown Court. Once you've been doing the job for a few years, preparing a shoplifting case is likely to be probably 6 to 8 hours preparation time. If you're engaged in a murder, however, you're talking about tens and tens of hours. And if you're talking about a fraud case, you're talking about hundreds and hundreds of hours. And expecting barristers to be in court for these periods of time is just not realistic.
Max, give me some idea of remuneration for all of this. If you're putting 8 hours preparation into a shoplifting case and then doing 5 hours in court, what would a barrister expect to be paid?
A shoplifting case will pay all in about £500, maybe £600. And again, as you will know, the headline figure of a barrister's fee doesn't represent their take-home pay. The vast majority of criminal barristers are self-employed. They belong to chambers. They pay rent to those chambers. They have to account for VAT. And of course, there's no paid sick leave, parental leave, holiday leave, anything like that, no pensions. So once you start taking all of those out of that figure, it dwindles down to a very modest figure indeed. And it's always been a huge frustration for criminal barristers that in the media and the press in particular, headline figures of sums paid out in legal aid often get headlined as though that was the take-home pay of the barrister. And it's a totally misleading bit of disinformation that fundamentally, to my mind, undermines trust in the criminal justice system, undermines trust in barristers, and it's just a complete misrepresentation of the reality of our incomes.
If someone wants to learn more, Max Hardy, about problems in the criminal justice system, is there a book or another source of information that you'd recommend?
Well, of course, I've got to recommend both of the Secret Barristers books, the more recent of which, Fake Law, is an extremely important corrective to exactly that kind of disinformation which I've described. And I regret to say that it sometimes suits the government for this kind of disinformation to circulate, because it means that there's never any kind of electoral appetite for increased funding to the criminal justice system. And it is a system that is absolutely crying out for funding. This backlog that has grown up, not since COVID started, because this is a consequence of years of austerity, court closures, reduction in what are known as court sitting days. It is absolutely eye-watering. It's running to tens and tens of thousands of cases. And this includes really serious cases of the most serious violence, the most serious sexual violence, and a massive cash injection is needed into the criminal justice system to get the train back on the rails.
That was Max Hardy, a barrister specialising in criminal law from 9 Bedford Row. Max, thank you very much. You're listening to the LBC Legal Hour with me, Barrister Daniel Barnett. The time is 9:42.